All right, good afternoon, everyone. Welcome to today's webinar on immigration detention landscape. My name is Elizabeth Gibson. My pronouns are she, her, and I'm a managing attorney for capacity building at the National Immigrant Justice Center. This webinar will provide an overview of the current state of play for immigration detention and recent events, including practical information for legal practitioners. The session should be interesting regardless of your level of experience with immigration law. That said, this is not an introduction to immigration detention course. If you are looking for a broader detention primer, I would recommend for NIJC staff to attend our internal summer intern training by the Detention Project on June 10th. For everyone else, there are lots of trainings available online, and please stay tuned for more trainings on detained work from NIJC as well. Today, we will be talking about the history of immigration detention in Illinois, including the state's new ban on immigration detention and the launch of the Midwest Immigrant Defenders Alliance as Illinois residents are sent to out-of-state detention centers. The training also will address what advocates should know about a settlement on warrantless ICE arrests and vehicle stops that goes into effect this summer. While our focus is on the Midwest, it should be a worthwhile conversation regardless of where you practice, with similar issues being seen in pockets across the country. Hopefully you will walk away with some practical information about how this may affect your work, clients, or community. I have a few quick housekeeping items before we launch into today's discussion. First, today's session will be recorded and posted on the NIJC YouTube channel within 1 to 2 weeks. However, if you want CLE credit or a certificate of attendance, you must attend today's live session and submit the evaluation form, which I will share in the chat. And it also should be listed in the agenda and will be circulated by email as well after the session. We offer Illinois CLE credit or certificates of attendance that you may be able to use to request CLE in a different jurisdiction. There also will be 2 CLE codes, so please listen attentively because you will need them for credit. I won't post them in the chat. You have to be listening. I'll say them a few times, but please make note of those when you hear them. You also may type questions throughout the webinar, and we will have time to go over those at the end of today's session. In addition, materials, including today's slides, can be found under the handouts section in GoToWebinar and will be circulated after the event as well. Now, let me introduce today's speakers. We are honored to have with us Fred Tsao, Senior Policy Counsel at the Illinois Coalition for Immigrant and Refugee Rights, Ruben Loyo, Associate Director of NIJC's Detention Project, and Mark Fleming, Associate Director of NIJC's Federal Litigation Project. With that, I'm going to turn the floor over to Fred to get us started with the history of immigration detention in the region. Fred, take it away.
Okay, thanks, Elizabeth. And thank you, everyone, for participating in this session this afternoon. I see some familiar faces and names, or familiar names among the attendees. I hope this will be a good productive session. So let's go to the first slide here. Okay. So this first slide lists the facilities that the ICE Chicago Regional Office had been using pretty much throughout the past 10 years or so. And you'll see there are, at any given time over the last 10 years or so, up until last year, ICE was using anywhere from 7 to 8 facilities. 4 of these facilities were in Illinois. Pulaski and Mchenry had been in use by ICE for at least the last 15 to 20 years. Kankakee is a relatively new addition. ICE started using that county jail, the Jerome Combs Detention Center, back in 2016. Also, for a brief while, ICE was using the jail in Jefferson County, which is in southern Illinois. ICE actually yanked the contract from that jail back around 2016 or so because due to lack of adequate medical care. The lack of medical attention was so bad that even ICE had to pull the contract. And then there were 4 additional jails outside of Illinois that ICE in Chicago was using. 2 in Wisconsin, Dodge up in Juneau, Wisconsin, and then just over the Illinois border, actually 2 jails in Kenosha, Wisconsin. I should note here that the Kenosha contracts were ended by ICE right when the pandemic began, because the sheriff in Kenosha was refusing to accept any new people who were being sent in by ICE, either as new placements or as transfers due to COVID concerns. So pretty much out of spite, ICE pretty much terminated the contract. And then Clay County in Brazil, Indiana, and Boone County in Kentucky, which is just outside Cincinnati. I should note here that the Chicago area of responsibility actually includes 6 states: Illinois, Wisconsin, Indiana, Kentucky, and then Kansas and Missouri also fall under Chicago jurisdiction. So that meant that ICE in Chicago was also using a number of county jails in Missouri and Kansas for ICE detention, primarily for people whose court cases were in Kansas City, though there were some people, particularly from Southern Illinois, who were also moved to Missouri and Kansas. So if we could move to the next slide. I think it's also important to note that ICE for the longest time had also been trying to build out additional detention capacity throughout much of the last 11 years or so. And in particular, ICE was in the market for a larger scale facility. And when I say larger scale, I mean 800 beds or so. And, primarily they were looking at private prison companies to develop proposals and submit bids for such a facility. So you'll see here, a list of many, of the various attempts by ICE to construct such a new facility in the Chicago region, as well as a few other site fights. Noting here the fight in Winnebago over the Winnebago County Jail in Rockford, which for a month or so was considering leasing out unused bed space in the jail for ICE detention. But for the most part, these again were some of the major players in the private corrections industry, trying to establish a presence here in the Chicago region. Of the major proposals, 4 of them were in Illinois, 4 of them were Indiana. All 4 of the proposals in Indiana were defeated. 3 of the 4 proposals in Illinois were also defeated at the local level. That is, local residents, local leaders, assisted by ICRR, NIJC, and many other allies, were able to organize effectively to get local officials to reject a proposal. The one proposal that failed, that we failed to stop on the local level, was the one in Dwight, Illinois. That was 3 years ago, and I'll say a bit more about that. But I also want to note here that there have also been site fights in Mchenry County. This actually began in well before 2021, but it came to a head in 2021. I'll say a bit more about that fight a bit later on. And then most recently, there has been a fight to stop the expansion of Clay County, which unfortunately also met with defeat a couple of months ago. So the Clay County expansion is on track to move forward, though though that is still a developing story. So let's move on to the next slide. Okay, so I should point out as well that as further context, so in addition to all these site fights, there's also been a series of bills and other legislative initiatives here in Illinois and here in the Chicago region to you know to you know to decouple local policing from ICE enforcement. And you see here, starting in 2011 with the fight against the ICE Secure Communities program and the Cook County Detainer Ordinance. Chicago passed the Welcoming Ordinance, and then throughout much of the last 5 years or so, we've been, we, that is ICRR, NIJC, and many of our organizing partners and other advocates have been able to win a series of victories, again, and local law enforcement collaboration with ICE. I'll mention a few of these bills specifically. First off, there's the Illinois Trust Act, which passed 5 years ago, 2017, that barred local law enforcement from arresting or continuing to jail anybody based on an ICE detainer or an ICE warrant. It did actually occur to us that this legislation, read a certain way, could actually be interpreted to end ICE detention here in Illinois. We did not try out this theory, at least not we didn't try it out yet, but that was always something that was on our minds as a potential, as a potential way to block ICE detention or end the county jail contracts. I'll also highlight the 2019 bill, the Private Detention Facility Moratorium Act, and let's actually go to the next slide. So the impetus for this was the loss in Dwight. So if we couldn't beat them on the local level, if we couldn't persuade the village board to reject the detention facility proposal, we could go to the state level and get the state to enact legislation. Now, I should point out that the first attempt to pass state legislation was actually linked to the first site fight, the one in Crete, Illinois, back in 2012. We tried to get a version of this legislation passed. It did actually pass the state Senate. And then on the final day of the General Assembly session, May 31st, 2012, it fell one vote short of passing the Illinois House. It was the worst day of my life that did not involve a date. Fortunately, we had this legislation ready for the next time that we lost on the local level, and that turned out to be 2019 when we lost Dwight. So we dusted off this legislation. We made some modifications. Mark actually reviewed this legislation and made some crucial edits and wordsmiths to this. So what this legislation does, first off, I should point out that Illinois already has a ban on private correctional facilities, but that unfortunately does not extend to civil detention, and therefore would not necessarily cover a facility like the one that was being proposed for Dwight. So so we decided to build on that previous legislation to bar civil detention in Illinois that would be handled by private companies and private facilities. On top of that, due to the way that the Dwight deal was being structured, we also wanted to include specific language to bar some of those arrangements. Specifically, what Dwight would have involved is a per diem to be paid to the village for each person who is being held in the Dwight facility per night if that facility were to be built. So again, we wrote in specific language to bar that. So we were able to, this time around, we were able to get this legislation passed. Governor Pritzker signed it in June of 2019, which happened to be just before the window for bids to ICE for Dwight would have closed. In so many words, this legislation ended the proposal in Dwight and ended any similar proposals for a for-profit facility. So if we can move on to the next slide. The final piece of legislation, and the one that's probably the occasion for this session, is Illinois Way Forward. Now, Illinois Way Forward includes lots of other provisions that more definitively close the door on ICE, on local police collaboration with and communication with ICE. But the provisions that are probably the best known and that have seen dividends already are the ones having to do with ending jail contracts with ICE. So what Illinois Way Forward expressly bars jails, jails and local law enforcement from entering into contracts with ICE for purposes of ICE detention. And it also addressed the 3 remaining jails that had ICE contracts as of the effective date of the legislation. So those jails, again, Pulaski, Mchenry, and Kankakee, were required to terminate their contracts or send notice of termination of their contracts no later than January 1st of 2022. Now, Governor Pritzker signed the legislation on August 2nd of last year. The effective date was immediate, and that meant that the clock started ticking so far as the closure of the 3 remaining jails. And I know Ruben is going to will cover much of what happened in the aftermath. But let me close off by coming back to the McHenry County fight, and I know there's at least one veteran of that fight who's listening in on this session. There was a very powerful group of local leaders that had been organizing to end the contract in McHenry County, trying to persuade the county board to enact a resolution to end that contract. Because as detention numbers plummeted during the early days of the COVID pandemic, the county was seeing much less revenue based on ICE detention at the jail. So that provided an opportunity to try to push for that resolution. Unfortunately, the county board rejected that resolution in May of 2021, which, by the way, happened to be the same month that the Springfield Advocacy for Illinois Way Forward was coming to a head as well. The county board held a couple of public hearings. During one of those hearings, a woman named Kristen Glauner spoke about her husband's case. Her husband is Cesar Elizaraz. Cesar had been in custody at McHenry County for 21 months. He's an undocumented immigrant he'd had some scrapes with the law. He had served out a sentence for a misdemeanor offense and then was immediately transferred from one floor of the McHenry jail to the next floor. And around the time that Illinois Forward was taking effect, Cesar was running out of his appeals, and the energy that went into closing the McHenry jail transferred into a campaign to free Cesar. Fortunately, thanks to a lot of really effective local organizing, a nationwide petition drive, as well as communications with with ICE leadership at the time, we were able to get Cesar get Cesar to not only get a hold on his deportation, but also ultimately released. And that happened almost exactly a year ago, right before Father's Day. So if we could actually move forward 2 slides. Okay, and this is from the night of his release. His extended family all gathered at Cesar's house and celebrated. And it just so happened, again, not only was it Father's Day weekend, but also it was Kristen's birthday the very next day. So Cesar's case illustrated what we were looking for once Illinois Forward was to take effect. And if we could actually backtrack 1 slide. So when the jails closed, we wanted the closures to happen in a fair and transparent fashion. So basically we wanted ICE to default to releasing people in custody as opposed to transferring them elsewhere. We wanted to make sure that the review process for the cases of the people in custody was a meaningful process, that people had the opportunity to make the case for release, that they were able to communicate with counsel, with family members and others who can help them build their case, and to also make sure that people were not transferred before they had the opportunity to make their case. We also wanted to make sure that, again, this was a transparent process, that people were notified of their ability to make the argument for being released, and that legal counsel, and organizations like NIJC had the opportunity to find out who was in custody, and to be able to reach out to those individuals. And then finally, once the releases happened, we wanted to make sure that those releases happened in a safe way. We heard too many cases, for instance, of people being released from Pulaski, which is in far southern Illinois, and essentially abandoned on the side of it, on the side of an access road to an interstate. Not even being given the opportunity to go to a bus station or train station. So, we specifically here in Chicago, we have been working with the interfaith community for detained immigrants, which has been doing a lot of work in helping people who are transiting through the downtown Chicago Greyhound station. And so we were lifting up the Greyhound station as a reasonable place to stage the releases. Rather than, again, leaving people by the side of the road. Let me stop there, and Ruben can take up the rest of the story regarding the closures.
Thanks, Fred. And do you want to go to the next slide, Elizabeth? The next one, actually. So I'm going to go ahead and just talk for a few minutes about how the Illinois Way Forward Act was implemented and some of the rapid response efforts that we worked on to, as Fred was sort of articulating, work towards this concept of just closures. So all of those principles that Fred laid out in that slide were really, we were articulated and really began to take shape once we got wind that Pulaski County Jail was going to be the first to shut down its operations for ICE. That announcement really came as a surprise. It was just a few days after the governor signed the legislation. And I say it came as a surprise because, as Fred indicated earlier, for the counties that participate in ICE detention, these contracts are a significant source of revenue. So I think, organizations that have been working on these issues were fully expecting Pulaski and some of the other counties to fight implementation of the act. That wasn't the case with Pulaski. There was no formal announcement. In fact, we found out about the imminent closure of of ICE operations in Pulaski, almost in just a really casual way through unrelated litigation. We got news that the county was planning on shutting down ICE operations almost immediately. The way that was announced and sort of made known to us immediately raised red flags that we perhaps weren't going to be seeing the meaningful process of review that Fred laid out in the prior slide, addressing what we mean by just closures. So for those of us who have worked with individuals at Pulaski County Jail and who have members, community members who are detained there, coming up with a response effort and ensuring that ICE was affording a meaningful review process was urgent for all of the reasons that Fred mentioned. If you look on the map, Pulaski County Jail is at the southern end of Illinois. It's 5 to 6 hour drive from Chicago, over 300 miles. And we at NIJC have had clients over the years who, as Fred was mentioning, were released from the facility and with no transportation arranged for them to get back to their community. And so in light of that experience, we really wanted to ensure that ICE was going to be ending ICE operations in a way that allowed attorneys working on these cases and individuals in detention to receive adequate notice and an adequate opportunity to request that they be released. As a side note, I'll also just mention that during this time period and during 2021 in particular, Pulaski was also just receiving a lot of attention for wrong reasons. During the pandemic, Pulaski was consistently the one facility that struggled to really control COVID-19 outbreaks at the jail. Of the facilities that detain people who are facing removal proceedings in the Chicago court, in fact, Pulaski has had the highest rate of COVID-19 transmission. Over 100 cases were identified, positive cases were identified at that facility. We filed a complaint with the DHS Civil Rights and Civil Liberties Office in March of 2021, also calling attention to inadequate medical care at the facility and the failure of the facility to provide particularly chronic care. And that was followed a month later by a surprise inspection and report from the DHS Office of Inspector General, which found that and confirmed what we knew all along, which is that Pulaski was failing to take adequate precautions to prevent the spread of COVID-19 in the jail, specifically by failing to ensure adequate masking and failing to ensure adequate social distancing. So all along, we've been concerned about the conditions at Pulaski for people who were detained there. And in light of the closure of the facility, NIJC and all of our partner organizations also wanted to ensure that a meaningful process would be set in place for folks to be released rather than transferred to other jails outside of Illinois. Next slide, please. So as I mentioned, the announcement came almost as soon as the governor signed the bill. And really there was a flurry of activity over the course of 3 weeks. Almost at the outset, it was clear that a lot of what we were asking for was perhaps not going to be provided by ICE as it shut down its operations in Pulaski County Jail. NIJC, ICE, or other partners, ICDI, the Organized Communities Against Deportation, we engaged in multiple engagements and stakeholder engagements with ICE to work out a process for them to review the case of every individual who was detained at Pulaski at the time. At the time, it was around 50 individuals, which was far below its peak population prior to the pandemic. Nationwide, we saw a reduction in the detention population during the pandemic, and Pulaski was no exception. And so from our perspective, this is really a unique opportunity for ICE to really reconsider its use of detention in each and every case. But unfortunately, as I mentioned, the red flags were everywhere, and the first indication we got from ICE was that they would just give us a really brief 48-hour window to submit requests for them to consider release for individuals, which is obviously an insufficient amount of time for even for those who had counsel to get together the necessary evidence to make the case to ICE as to why they should be released. For folks who did not have detention, I mean, this was an impossible deadline really to meet, and we were concerned that there was not a sufficient window for individuals to get meaningful review of their cases. So after significant community pressure, we were able to get a bit of an extension, but it was still a very abbreviated process. And over the course of really just 1 week, we and all of our partners worked really tirelessly to ensure that there was a submission of a release request for every individual who was remaining at Pulaski. Of course, Friday before Labor Day weekend holiday, we started getting notifications from ICE, really just boilerplate decisions, denying the vast majority of all of our release requests. We later found out that of the 50 or so individuals who were detained at Pulaski at the time, only 3 were actually released. All else, everyone else was transferred to other facilities, including Kankakee, the other Mchenry County Jail, the other 2 Illinois jails that were still detaining people. But we also had some individuals who were transferred out of state. That, of course, was disappointing and was not in keeping with the spirit of the Illinois Way Forward Act, and was also just not providing the type of robust review that we were asking for as part of our Just Closures advocacy. So that triggered really a series of follow-up engagements and advocacy and outreach to ICE, but also other stakeholders to at least get ICE to do a second look, to provide another opportunity for individuals to receive reconsideration of their cases. And we were successful to some extent, and a few weeks after the decisions to transfer were made, we learned that 14 of the 50 or so individuals who were initially detained at Pulaski were released. So we were able to get ICE to reconsider and release individuals whom they previously had deemed should be transferred to other facilities. Next slide, please. So as all of this was happening, the other 2 counties that were still detaining individuals in Illinois sued in federal court, and they sued to stop implementation of the Illinois Way Forward Act. I won't get into all of the details of the claims that they raised in their litigation, but this was sort of in keeping with what we expected, right? That the counties would fight this act and fight this piece of legislation because it's a significant source of revenue for them. But the lawsuit actually was dismissed by the federal district court in early December. Nevertheless, the counties continued to fight that. They filed an appeal to the 7th Circuit Court of Appeals, and also sought an emergency stay of implementation of the Illinois Way Forward Act. The circuit granted a brief stay for the purpose of allowing the parties to brief all of the issues, but ultimately denied that stay on January 13th. And at that point, the Illinois Way Forward Act and the termination provision specifically went into effect. The appeal remains pending, I believe, and it was recently argued at the circuit, and we're expecting a decision soon, but all along, so far at least, the federal courts have not been receptive to the county's arguments. Next slide, please.
Very briefly, before we go to the next slide, I'm going to give our first of 2 CLE codes. So everybody, if you've been dozing, wake up. The CLE code. First one is forward, as in the Illinois Way Forward Act. That's FORWARD. Forward is the first CLE code. I'm not going to put it in the chat, so please write down forward as your first of 2 CLE codes that we'll have today. And I'm going to turn things back over to Ruben now.
So soon after the lawsuit was dismissed at the district court, ICE really began to, this time around, plan for the anticipated closure of and the end of ICE operations at both Mchenry and Kankakee. So around the end of 2021 and in the beginning of the year, we stopped seeing a significant number of new arrivals at both of the jails. And in anticipation of the implementation of the act and the termination provisions in the new year, the same coalition partners renewed all of our advocacy efforts, trying to ensure that this time around, ICE would engage in a meaningful process of review of all of the individuals that were detained at these 2 jails. This produced mixed results. So sometime in mid-January, ICE announced a process. This time we received more notice and more time to submit requests for release on behalf of all of the individuals, which was obviously some improvement from the experience of Pulaski, but it was still an abbreviated period of time. Advocates and detainees were given until the end of January to submit release requests to ICE. At the time that they announced this process, it already was clear that ICE had been engaging in their own internal review of some of the cases and had already started making some decisions to either release individuals or detained. Some of that was occurring without a lot of notice to stakeholders and attorneys and other advocates who were working on some of these cases. But by the end of this process, as opposed to sort of what we saw in Pulaski, we did see a significant number of individuals released from both Kankakee and Mchenry, of the individuals who were remaining at those 2 jails. At the beginning of the year, there were somewhere around 75 individuals who were detained at both facilities. And by the end of the review process, over 50%, around 40 and 41 individuals were released, which was a success. Obviously, we were happy to see that. That having been said, a not insignificant number were transferred to other jails outside of Illinois, including in Indiana, Kentucky, but also facilities as far away as Oklahoma, where we followed some of these cases and continued our advocacy efforts on behalf of those individuals who were transferred. I'll add that all of this, so this rapid response effort, the rapid response effort really came about in the absence of any sort of clear policy or process that had been articulated by ICE. ICE's response to sort of our advocacy had been sort of ad hoc. And after the closure of the 3 Illinois ICE detention centers, ICE issued a standard operating procedures document, which is really informed by the experiences in Illinois to guide future facility closures. And it doesn't incorporate many of the principles that there are outlined in our just closures, in the just closures, in the vision of just closures that Fred laid out. But it does provide for some of the things that advocates have been asking for all along, including stakeholder engagement, notice to attorneys and communities and advocates about the imminent closure of a facility, and the provision of an opportunity for individuals to submit release for requests. So that is hopefully a document that advocates should consult as they prepare it, particularly in other states, for closures of jails and ICE detention centers in their region. Next slide, please. So Fred had sort of the list set out earlier, and I just wanted to go back to it for a second just to illustrate the impact of the Illinois Forward Act. So as of the March of this year, we now, there are 4 fewer detention centers that are holding immigrants in our part of the country. And that represents, at their peak, all of these facilities were maybe detaining over 500 individuals combined. And, detention at these facilities was obviously generating a lot of revenue for these counties who were profiting off of the incarceration of immigrants. So it goes without saying, but it's the Illinois Way Forward Act and the closure of these jails has made a significant dent on immigration detention in the Midwest. And as of March of this year, only 3 facilities remain that continue to hold people facing removal proceedings in Chicago. That's Dodge in Wisconsin, Clay in Indiana, which, as Fred mentioned earlier, is planning on expanding its facility, and Boone County Jail in Kentucky. Next slide, please. So I'll talk for just for a few minutes about sort of what's next for us, right? So we were successful in closing down immigration detention centers in Illinois. What's next for us as advocates, and for our communities. And one of the things that we are working on now, post Illinois Way Forward Act, is an initiative to expand representation for immigrants in detention. You might be thinking, why, given that we've closed all of these jails in Illinois? And the short answer is that there's still a not insignificant number of individuals who remain detained in the region and face deportation proceedings in the Chicago Immigration Court. And there's obviously there's no established right to appointed counsel for indigent immigrants who are detained. Nationally, the statistics have been that anywhere between 60 and 80% in recent years of individuals in detention have been unrepresented. And that's been largely the case in Chicago as well, where the data shows that somewhere around 60% of individuals who've been detained who are in Illinois have been unrepresented in immigration court. And studies have also shown that the provision of counsel greatly influences and impacts the likelihood that an individual will be successful in their case. And so, given that we now are, we're seeing less individuals in detention, this is actually a prime opportunity for us to work towards ensuring that everyone who remains in detention gets counsel. Next slide, please. So this is just a chart from from Track Immigration, which compiles data on the immigration system, just showing how high the percentage of people who are unrepresented and detained in the Chicago court has been over the years. As I mentioned, it's been around 60% in recent years. Next slide, please. So before I end, I just want to mention a few of the things that we've been working on to work towards increased representation for those who are remaining in detention. The first is that we just launched a universal representation pilot program along with partner organizations, including the Resurrection Project, the Immigration Project, and the Cook County Public Defender Office, which for the first time is now representing individuals in immigration court. And that's due to other legislation that Governor Pritzker recently signed, which amends the county's code to allow large public defender offices to represent immigrants in immigration court, and that went into effect this year. So all 4 of us are partnering together to work on expanding representation for detained immigrants. This is also happening at the same time that new legislation went into effect. The governor just signed the Right to Counsel in Immigration Proceedings Act, which establishes a task force to study how the state can provide universal representation to everyone who's facing removal proceedings in Illinois. And the task force will, over the course of the next year, sort of study how it is that the state can accomplish that. And our goal is to, as a collaborative, to hopefully inform some of the work of that task force. Next slide, please. So I'll end just by giving some brief information about our pilot program. Collectively, we're the Midwest Immigrant Defenders Alliance. As I mentioned, it's a collaborative of 4 organizations, and we're working towards universal representation in the Chicago court. But really, the region and the MEDA really sets forth a new and innovative model to respond to what is a regional problem. It includes organizations not just from Chicago, but also from downstate Illinois. And our hope is that in the future, we can grow that into a network of organizations that can respond to the needs of immigrants detained across the Midwest. So as of now, it's a 1-year pilot program. And basically, we only screen for income eligibility and representation status. And we screen all cases on 1 docket in the court every 2 weeks. We encourage you all to visit our website if you want more information about how individuals can access our services. This is just a pilot year, but our hope is that over time, it will grow and we'll get to a point where, as I mentioned, everyone who is detained and can afford counsel is able to obtain high quality representation. I'll end there and pass it on to Mark.
Very briefly, I just want to jump in with your second CLE code. The second CLE code is Alliance, as in the Midwest Immigrant Defenders Alliance. That's ALLIANCE. The second CLE code is Alliance. And I'll also just flag for anybody who's joining us now, there are 4 handouts, including the slides and agenda in the handout section. And one of those handouts also is a flyer on the Midwest Immigrant Defenders Alliance for anybody who's interested in more information on that. And I will now turn things over to Mark.
Hi, everyone. Thanks for joining this webinar. I'm going to talk a little bit mainly about the Castañon Nava settlement that was just recently finalized and its implications for ICE enforcement and arrests in the Chicago field office. And I think as Fred had mentioned, the ICE Chicago field office encompasses 6 states: Wisconsin, Illinois, Indiana, Kentucky, Kansas, and Missouri. And then time permitting, I wanted to talk a little bit about some of the implications for the other aspects of the Illinois Way Forward Act and what its implications are as to ICE enforcement within the state of Illinois. But before I do any of that, I did want to raise something about the Clay County expansion. I think we've raised this as like this is something that's going forward. I did want to flag that NIJC, in collaboration with our allies and the organizers in Indiana, have filed a rather substantial class action lawsuit that, amongst other things, implicates this profit motive that we're seeing with these county jails that, you know, if we're successful, may have some significant implications for that expansion. But perhaps that will be in a webinar in a few months once we have a better sense. That litigation was just recently filed, and so it'll be a few months before we know exactly what's going to transpire in that case. Before I talk about the Nava settlement itself, I did want to flag in the materials some important documents that I really encourage you to look at to better understand what its implications are. We've included the settlement agreement itself, which obviously contains a lot of legalese. So just so that everyone has the full settlement itself. But then an FAQ, both in English and Spanish, that summarizes some of the key components of the settlement and what its implications are. And then finally, we included a draft, and I'll emphasize draft, of a screener document that we are intending to push out to allies so that they could report potential violations of the Nava settlement. It's a shorter document, and it incorporates the types of information we will need in order to assess whether there's been a violation of the Nava settlement. And it's important for us to get this information because there are certain remedies that I'll go into for individuals, class members, individuals who are impacted by the settlement, and things that we can do as NIJC and class counsel to get relief for those individuals. I flagged that it's a draft. We still need to add in there what is going to be the final email address for where to send that information. that hopefully we will be able to follow up very shortly with that final version. But that also is in English and Spanish for allies. And then one last thing with respect to NIJC staff, we're working internally to add a few questions to Legal Server that will help us to identify potential violations of the Illinois Way Forward Act, i.e. when state and local law enforcement are collaborating with ICE impermissibly under that state law, with hopefully opportunities for us as litigation to seek redress in collaboration with the Illinois Attorney General. And then also a couple of screener questions, again, briefly, that would ping cases of potential violations of the Nava settlement so that we as class counsel can follow up with the government and hopefully seek relief in the instances in which there have been violations. And so what is the Castañon Nava case? What it grew out of was one of many large-scale enforcement actions by the Trump administration back in the spring of 2018 that had the goal of punishing or holding quote unquote sanctuary jurisdictions accountable. And how these enforcement actions or large scale enforcement actions were conducted was, and this was very typical of ICE and continues to be very typical of ICE enforcement actions, is that they have a list of a few target individuals that they're seeking enforcement against. And then once they're saturated into the community, anyone they encounter, quote unquote, collateral arrests, they pick up in the process. So for example, in the Chicago lawsuit, I think there were maybe 10 to 15 targets, but they ended up sweeping up 150 individuals. And so with the help of our detention team and our allies, FRETSAU and ICIR and OCAD, Organized Communities Against Deportation, we identified a number of individuals who were arrested in that enforcement action. And then also ICIR and OCAD were organizational plaintiffs in that lawsuit. And, you know, to kind of put a little color on this particular enforcement action, one of the things that we were seeing was ICE indiscriminately pulling cars over in, you know, known Hispanic communities within Chicago and the Chicagoland area, and then seeking to question the individuals in the car as to their immigration status, which, you know, we argued in the lawsuit was essentially racial profiling. These were pretextual stops that had no basis under the Fourth Amendment for the stop in the first instance. So after we filed the lawsuit in May of 2018, after about a year of litigation, the government approached us about a possible settlement, and it took probably about another year for us to reach that settlement. But where we've landed is, you know, I think a very positive, powerful tool that we have going forward that has implication not only for the ICE Chicago field office, where we have specific remedies, but also nationwide. The government agreed to issue a new policy nationwide that actually went out on May 27th. So it has been issued out to all ICE field offices that establishes a new policy as to when ICE can make warrantless arrests in the community. And this is particularly targeted at this idea of collateral arrest, people that ICE hasn't targeted in advance and for whom they haven't obtained an administrative warrant. And then as a subcomponent of that, as I just mentioned, is this idea of when it's appropriate and under what circumstances and what things does ICE need to do when making vehicle stops. And so what are these? So under the INA, ICE has limited warrantless arrest authority. They need to both have probable cause that the individual is removable, but also they need to have probable cause that the individual is likely to escape before a warrant could be obtained for that person's arrest. For years now, decades, we know ICE has been violating this. And so finally, after probably 40 years, we now have an ICE policy that lays that out for all ICE officers, that they need to have both those prongs of probable cause. And what does it mean to have probable cause of likelihood to escape? When this has been challenged before, the courts and former INS agreed that when an individual has a home, ties to the community, a job, family, these are all indices that the individual is not likely to escape. And so under this new policy, when making an arrest in the community where they don't have a warrant, they need to make an assessment based on those factors and others, whether they can figure out the person's identity, has this person fleed ICE before, etc. So some negative factors, but some of these positive factors that they're not likely to escape. And only can they make that arrest if they determine on the totality of all these factors, including dealing with these community ties, that the person is likely to escape. Now, when they make such an arrest, under this new policy, they need to document in the processing soon after the arrest on the I-213. So I think if folks know, the I-213 is like the arrest record. It's the processing document for placing someone into ICE custody and then potentially, issuing them an NTA and placing them in removal proceedings. On the I-213, they need to be documenting the factors that they considered, including affirmatively addressing these factors as to community ties and why, despite any sort of community ties, the individual is likely to escape. So our belief is that under most circumstances, this should lead to no warrantless arrests in the Chicago area and also in the Chicago field office area. Now, however, we are only here in Chicago, and so we really need the assistance of folks in the communities and allies in these other states to bring to our attention individuals who may be subject to a warrantless arrest unlawfully. The other piece of the policy is as to vehicle stops. Under this policy that has been issued now nationwide, ICE cannot make a vehicle stop based on any allegation that they are enforcing state or local traffic laws. That cannot be a basis for the arrest, and they cannot state to the driver that that is the basis of the arrest. In addition, they need to have reasonable suspicion. So this is the kind of Fourth Amendment standard. They need to have reasonable suspicion that there is an individual in the car who is in the country unlawfully before making the arrest. And if they do end up making an arrest, they need to, again, as with the warrantless arrest prong as to probable cause and likelihood to escape, they also, in the I-213, need to be documenting what are the particular facts that led them to have the reasonable suspicion that there was a person in the vehicle who was unlawfully in the United States. In addition, under both these prongs of this new policy, they need to be identifying themselves as ICE officers. So as I said, that went into effect and issued nationwide on May 27th. We've now entered in a period of 45 days in which ICE needs to train all of their officers in the Chicago field office. And so I think the cutoff is July 11th, by which time all officers in the ICE Chicago field office need to be trained. And then it also has triggered 180 days by which ICE officers nationwide need to be trained on this new policy. So around Thanksgiving, November 23rd, I believe, is that cutoff. So starting on July 11th, we want to start to be looking for potential violations of this policy. Soon thereafter, ICE needs to affirmatively present to us as counsel to NIJC. They need to give us all the I-213s of individuals who were warrantlessly arrested in the Northern District of Illinois. So about the top third of Illinois. In addition to that, while those are the only ones they need to affirmatively give to us, if we have any evidence that anyone else has been warrantlessly arrested, whether at their home, at a place of business, in the community, or pursuant to a vehicle stop, we can raise those cases with our opposing counsel and try to obtain the I-213 in those cases. If we identify violations of the policy, and this includes not only did they have probable cause, but did they document it? If they didn't document any of this evidence in the I-213, even if they could, post hoc say that they had probable cause, that's not going to be good enough. And so we then have remedies in which the government has agreed that if there is a violation of the settlement as to an arrest that occurs in the ICE Chicago field office, so that 6-state region, Wisconsin, Illinois, Indiana, Kentucky, Kansas, and Missouri, that if there has been a violation, assuming the individual is not subject to mandatory detention, that the individual must be released. And if they had already been released on bond or on some conditions of release, that those conditions and or the bond money needs to be returned immediately to that individual. In addition, if we have identified a violation, the officer that committed the violation is subject to remedial measures that they need to report to us under the settlement agreement. And to the extent that we do identify a pattern of violations, we can go to the court and seek even more measures against the government to get them back into compliance with the settlement agreement. We have this power for the next 2 to 3 years. The government can try to move to end the settlement before the end of those 2 years, or excuse me, after 2 years. But also if there are, repeated violations through this kind of escape clause, we can seek further measures from the court that potentially could expand beyond the 3 years. I'll flag also that under the settlement agreement, it is clear that after 8 months, this policy can be used as a basis for litigation elsewhere in the United States. So as I said, they had 6 months to train people nationwide. The government has agreed that this can form the basis of follow-on lawsuits in the event that there are violations elsewhere. We couldn't make this a nationwide class because we were only targeting one area. So I'll stop there. I think what I would just like to say is that take a close look at the FAQ and the screeners. We'll be following up with a follow-up screener in some of the processes that we intend to implement in order to monitor and really need everyone's participation in monitoring for potential violations of both the Illinois Way Forward Act, but then also as to the Nava settlement. And then I guess the one last thing I'll say is that as we were just speaking, I just got an email from opposing counsel that the named plaintiffs in this case are having their removal proceedings dismissed and are in the process of receiving deferred action under the lawsuit that hopefully will provide them more stability, as many of these individuals have long roots in the community and have contributed in so many ways to the vitality of this city. So I'll stop there.
Okay, wonderful. If anybody has questions, please go ahead and type them now while we're waiting for people to come up with their questions. I'll just remind everybody, we have about 15 minutes for questions, so feel free to add those now. If you are seeking CLE credit, a certificate of attendance, you're going to need to complete an evaluation. I'm going to post that link in the chat once we're done with Q&A, but it will also be circulated by email. And just while we're waiting for questions to come in, is there any updates on what fights are going on around these detention centers that remain open outside of Illinois?
Are you referring to the remaining the facilities that are open?
Right, Clay, Boone, etc.
Yeah, so in the Clay, I'll just mention the Clay County. There were, as this expansion was going into consideration by the county, and this is kind of where the two things played off each other. The Illinois Way Forward Act, we had filed with allies an amicus in the case. An amicus is a friend of the court brief in the Mchenry litigation, in which we uncovered that in the case of Mchenry, anywhere from 45 to 73 cents on the dollar that they were receiving was not going to the custody and care of the ICE detainees. That this was money that was going back into the county to pay for jobs, roads, you name it, but not to the purpose in which they were. And so we learned soon thereafter that Clay County was doing the same thing, that a lot of the money that ICE had said, you must use this for the care and custody of the folks under, under our detention, Clay County likewise was siphoning off and misappropriating significant portions of those funds. It just so happened at the same time, Clay County had failed an inspection. So the money that really could have gone towards, them meeting the standards of care that they were required to follow, they were woefully failing on. And so that lawsuit is challenging both this misappropriation of funds, which, I think we're hopeful will have an implication on the expansion, but also, frankly, this profit motive that has brought so many counties and, frankly, private prisons into immigration enforcement. But then also challenging real problems with ICE's accountability as to detention standards for people in their custody through these contracts.
Okay. And we have a question. Someone has asked, does Nava apply retroactively or not?
It does not. It goes, the trigger date was our agreement on the training materials, which was April 27th. And so really we're not going to be easily able to enforce it until all of the ICE field office, all of the ICE officers in the Chicago field office are trained. So I really kind of target any arrest after July 11th as the real starting date.
Okay. And
I'll
a
just
question.
add to that too.
Go ahead.
No, I was going to add to what Mark said. Like, even if there's no retroactive application, if you think it's a case that sort of implicates some of the issues, it's also likely a case that may potentially raise suppression arguments in immigration court. So there might be like independent remedies for you to just like think about as you proceed with cases that, under the current sort of landscape and settlement framework might be Nava violations.
Can I just follow up on that really quickly, because it's one detail from the settlement I forgot, which is that as class counsel, as I mentioned, as to arrests in the Chicagoland area, we are going to affirmatively receive the I-213s. We are allowed, irrespective of whether there's a violation, we are allowed to share those with any immigration counsel or the person detained. And I think, as Ruben just flagged, they may, independent of the settlement, form a basis for suppression or termination of proceedings.
Okay, and then we have a question that's from the potential violations of the Illinois Way Forward Act that you've heard about. Are there any particular parts of the state that keep coming up, particular police departments? So I think they're asking geographically, are there problematic pockets of the state?
I'm not sure we know just yet, but the things to look out for are, if ICE receives someone by transfer from any sort of Illinois law enforcement agency, that's unlawful, irrespective of criminal history, whatever. It is unlawful for any state or local law enforcement agency to be transferring, detaining someone in order to transfer them to ICE. And then also the other one that's a little bit of a closer call, and this is something we're trying to work out on our end, is individuals who are picked up by ICE soon after, so maybe the same day as they're released from either a state or local law enforcement. In many instances, we have concerns that those also may be violations, because under the Illinois Way Forward Act, law enforcement, whether state or local, cannot be communicating with ICE about a person's release or sending to them affirmatively the individual's contact information, whether it's the address that they're being released to, their phone number, their email, their social media. And so those also, if somebody is arrested by ICE soon after a release from local law enforcement, that also for us is a red flag that there may be a violation. And I should just flag that under the Illinois Way Forward Act, there may not be something easily we can do to remedy for that individual. However, the Illinois Attorney General now will have very significant powers to seek enforcement against law enforcement agencies that violate it. And they have made very clear they have a commitment to remedying any violations. And so those sorts of potential violations from state and local law enforcement are critically important for us to know as well, and for us to pass on to the point people within the Attorney General's office.
All right, and another question, what about local and county jails with contracts with the U.S. Marshals or DEA? Who are they, who are then transferred to ICE custody?
Is the question as to federal? So a couple things. If when we've been using the term an ICE contract pretty colloquially, in the context of Mchenry and Kankakee, those were U.S. Marshal contracts in which ICE piggybacked. And so the law in the Illinois Way Forward Act is crystal clear, and the counties now concede that that rider, that use of the U.S. Marshals contract needs to be terminated by the county. As to the U.S. Marshal contract, even if as long as they're in the local custody, even if it were pursuant to that contract, they still cannot release that person to ICE or transfer them to ICE as the county or state officials. So I don't know if the existence of the U.S. Marshal contract itself does not change the fact that they as the county official or local official cannot be transferring that individual or communicating to ICE to facilitate that person's arrest. Now, it doesn't change the fact that if the person's in U.S. Marshal custody, them transferring that person back to Marshal custody or to BOP, and then the Marshals or BOP then move them, then that falls unfortunately outside of what is possible under the Illinois Way Forward Act, or what could be prohibited under the Illinois Way Forward Act. I hope that answers the question.
And if it doesn't, if the asker could feel free to follow up in the questions with that. Our next question is, does everything you're saying about Illinois law enforcement not being able to share info upon release from state custody with ICE apply to folks who had ICE holds on them from several years ago? And then also, if ICE reaches out to state law enforcement or IDOC to get information on a release, are they still unable to share information?
The answer is yes and yes. It applies to any detainer that's outstanding. And yes, if ICE reaches out to seek that information, they are prohibited by law to provide it. I think the one caveat in something Ruben and I have been talking about is we have seen a little bit of a pattern of, I think as folks know, on IDOC's website, you can find the release date of an individual. And so the one kind of gap, and I don't know if we have a full solution for it, is that, if ICE is looking for the release date and then following up on their own independent of getting information from state or local officials, we aren't really in a position probably to block that.
Okay, and we just have a minute left, and I don't see any additional questions. So I'll just remind everybody that if you're seeking CLE credit or a certificate of attendance, you must complete an evaluation form. I'm posting the link in the chat, but if you don't manage to copy and paste it in time, please don't worry. It will be circulated by email as well and is in the agenda that's among the handouts. And yeah, the handouts will also be circulated as well. So that concludes today's program. Thank you so much to all of our wonderful panelists. I haven't been reading them, but in the questions we've also had several shout outs of people saying thank you to everyone for this presentation. So thank you so much for sharing all of this information, and everybody have a wonderful rest of your day. If you are at the NIJC office today, just a quick reminder that there will be a walk. Join everybody down in the lobby in just a moment to stretch your legs a little bit in this beautiful weather. So hope to see you there if you're here at the office today. All right, have a wonderful rest of your day, everyone, and take care.
Thanks, everyone.